live?
We are live.
We are live. Good morning. We're live on the eDiscovery channel from beautiful New Orleans City Park, which is in the midst of celebrating, as you might tell from the sign, its 300th year anniversary. And it's a beautiful, blustery, gusting day here in the park. Thank you,
hat,
sir.
I had a hat when I came in.
Yeah, I've lost my hat.
Well done. Hello, everyone.
So,
I want to report that I've been on down to the Audubon Zoo, and they all asked for Tom. They all asked for Tom.
That's right. So we haven't done one of these for quite a while. Here, obviously, Craig Ball, Tom O'Connor, your hostess with Mostess, and we're going to talk something about eDiscovery. We really are going to get serious here in a moment.
Well, we are, Tom, but let us first observe where we are. We are in City Park.
Yes.
The beautiful City Park, the largest metropolitan park in any city in the United States. Did you know that?
It cannot be bigger than Central Park.
It is far bigger than Central Park.
Okay, we're gonna circle back to that fact with a little ESI search and devour later.
See this hat? Tom will be eating it in our next podcast on that point.
All right.
Larger than Central Park.
That's
indeed.
it for all of our viewers who have the answer to that. We want to know which is bigger, Central Park in New York or City Park in New Orleans.
And we are celebrating this year in a unique way here in New Orleans.
That's right. It's I can't remember how many years is our anniversary now.
I don't know. If I only had some clue.
If there was some sort of visual
no
prompt to tell me what it's. It's pick a number between 1 and 10.
No, it is the 300th anniversary, as you all can tell, looking behind us here in City Park on the beautiful Swanboat Lake. They have erected a 300-year, well, there it is, the 300-year erection.
Yeah, and I don't even know.
Be sure and call a doctor on that one.
I don't know what that is. Bicentennial, tricentennial? Tricentennial.
Try again. Centennial.
There we go. So anyways, enough of this tomfoolery, if you'll pardon the pun.
Perfectly chosen.
Well, this is the eDiscovery channel, and we do have a topic for the day other than proving to each other how amusing we are.
or disabusing anyone of any thought that we might be.
For the two of you who are still listening, I have actually been asked to, this is defying all of my previous experience doing these by having actual written notes. I've been asked to address the practical dialogue you would want to have with retained counsel before you accept an engagement to do a forensics examination. I'm sure, Craig, your initial dialogue goes something along the lines of, my fee is X, my retainer is X, no refunds, no phone, no pool, no pets.
That certainly would be my inclination. It's the first question today. Can you pay me? Pay me up front. But apart from that, there are
we have to be
concerns here.
All seriousness aside, folks, I feel like Steve Allen.
You know me as bon vivant, male model, etc. But no, in fact, I am a computer forensic examiner in addition to being a trial attorney. And so Tom has been kind enough to ask me to comment wearing my hat as a computer forensic examiner.
Wearing your expert hat, I see.
Clearly I have no expert hat.
So, Craig had actually sent me some questions, which I've, of course, in true legal fashion, taken the questions in the order he sent them and rearranged them to befuddle him.
Right.
It seemed to me the first thing was, your point here was explaining the forensics acquisition and examination process to the prospective client, which seemed to go hand in hand with what's it going to cost, how long it will take, and setting reasonable expectations. Would that be how you normally proceed?
Yes. Obviously, the client gets talk first, and in that context, many times the client will approach Tom with unreasonable expectations about what forensics can do. I mean, to begin, computer forensics, digital forensics requires me to have access to certain media that I can actually examine in my examination. And you'd be amazed at how many times I'm called and I'm told, we want you to do forensics, and I'll say, well, can you get me the computer or the phone or the device? And they go, oh, well, I hadn't really thought about that part of it, truthfully. Or they think that I can get it from just any computer that the file might have come in on. But for most traditional computer-based forensics, I need to have the device that was used by the, if you want to call it the suspect or the individual under scrutiny, and if it's an issue of I'm laughing because you're being attacked by
we're gassing aside because on the left of us here, doing their best Peabody hotel imitation from Memphis, is a bevy of little ducklings, and on the right of us is a mama duckling who is not quite sure she trusts us to be this close to the kids.
She's giving us the stink eye.
Yes. Well, as long as she doesn't start moving aggressively here. And I'm sorry, you were saying I'll keep an eye on the duck. Look at her. She's like, hey,
us, lady. You go get them away from here. Look at, they're getting closer. Mom. Okay,
there we go.
Now. Thank you.
Get away from those strange humans.
One of the wackier interviews I've ever done. All right, so the point is that I have to make sure, am I going to get to the evidence that lends itself to forensic examination?
And let me interject now.
Please, interject.
Do you have, there is a great amount these days of remote collection tools. Do you prefer to have the data, the device, if you will, in hand? Do you care about remote versus in your lab examination?
It depends upon, yes, I do care, but I care for different reasons. Mostly I care for keeping the costs as low as possible for my clients. Now, the first thing is that we've got to deal with the issue of access. And, you know, a lot of people have it in their mind, a lot of lawyers have it in their mind, that they can just get access to the other side's computer without considerations of protections necessary for privilege, for privacy, medical records, all the variety of things that permeate a device today. And so I think we have to realize that typically the expectation that the other side's devices are going to be turned over to you as counsel, opposing counsel, or to your hired examiner is a remote possibility. It should appropriately be a remote possibility absent some significant demonstrated malfeasance, so that it's more in the nature of a sanction by the court.
So am I hearing you say, though, that really when you bring this subject up at the beginning, you surprise your client?
Absolutely. They believe that they're just going to get the computer of the other side because they haven't considered how commingled that computer be, how rife it will be with unrelated, non-discoverable, and often privileged communications with opposing counsel.
Right.
So of course they would love to see it, but the reality is that there needs to be a huge and almost insurmountable hurdle for that to occur. Now, many of my colleagues will take a very different view. They'll say, I do it all the time and it's no big deal. I can choose what to share with the counsel that engages me. But the truth of the matter is, I view that relation to be a confidential relationship between examiner and counsel, and I would be hard-pressed to conceal from the counsel engaging me information that materially impacts their case potentially. And who am I to choose what they should and shouldn't hear?
Right.
And so unless I have the court backing me up on that, I have a protocol the court's put in place that creates that wall, I believe that that's just simply not a tenable approach. You either need to use a neutral examiner, or you need to force your opponent to hire a competent ethical examiner and put in place an agreed upon or court-ordered protocol for the examination and for how the data will be treated in terms of its review for privilege and privacy and irrelevance by the opposing counsel.
Now, let me interrupt if I could. Sure. You're talking primarily here about an opposing counsel and or party. But I've run into several instances where the client who has engaged us, when he or she sees the extent to which the examination of particularly a computer or computer system may develop, all of a sudden gets, shall we say, cold feet.
Yes.
And we get pushback, have gotten severe pushback from clients about examining a particular computer and how that's going to happen. And I can tell from the expression on your face, you're not unfamiliar with that scenario as well. How do you deal with that?
Not particularly familiar and not particularly sympathetic when a client has something on their computer that is that they view so prejudicial in nature, so intrusive, that they won't even confide in their counsel.
Often unrelated to the case, or at least in the two experiences I've had, not related to the case, but material of a nature that they did not want to disclose. And I don't mean to say anything was
Let's just say
untoward.
what we like to call fabric-free entertainment.
That was in
Porn
one
is
case.
a good example.
The other one was, without divulging anything about the case, a second set of books for the business. Although we were not looking at anything involving with that, that was not the nature of our investigation. In fact, it turned out that computer had some information the individual would have found embarrassing of a financial nature.
When I'm working for counsel and I am examining my counsel's client's computer, I can provide strong assurances that if it's unrelated to the matter, if it's outside the scope of what I've been asked to look at, that with one exception, I can respect that and simply act like it's not there. I am a fiduciary.
Yeah.
Keep in mind that I'm also an attorney, so I view the nature of my confidentiality. Yeah, apparently.
I didn't know that.
I'm
sorry. We should have said that at the outset.
It was a crackerback jackbox. That's right. Well, I never take that hat off.
Yes.
Absolutely. Not for one thing and one thing only, and I never take that hat off.
Well, I'm starting to get nervous about this interview then, however.
The point is that one exception is child pornography.
Right.
If I come across that, which is not a problem over the years.
Which we are all required to report.
Exactly. It's a strict liability crime, possession, etc. So there can really be no, really.
There's no wiggle room.
There's no wiggle room. Exactly. Yeah. I mean, I have to go straight to law enforcement. I can tell my client, the counsel, what's happening, but I cannot agree to conceal it in any way. But that's just simply so much non-entity, such a rarity, thankfully.
Yeah.
For the rest of it, that's not the scope of my work. I'm there. I'm hopefully that the counsel has enough of a sense of what's relevant in the case, what's privileged, that I can tailor the nature of the scope of my examination, the protocol I use, the search techniques that I use. I can be implicating unnecessary, irrelevant material. And I think that's why it's important to create expectations. What are we trying to accomplish? What is the protocol? I try, where possible, working as a neutral, I always try to have an established protocol so that both sides know. That one side, the side tendering the machine, knows they're going to get the data to examine it for privilege, confidentiality, be able to assert objections before it goes to the other side. I think that's an important protection to build into these processes.
So I've participated with you in the Georgetown Law School eDiscovery Training Academy, and I've seen you for a number of years now, your explanation of forensics acquisition. You show the students the various types of tools and explain. Do you go into that amount of detail in an engagement in explaining exactly what the acquisition is going to involve, or how much do you detail that process?
It depends on the concerns and the sophistication of the client. Many of my clients are people I've worked with a number of times. They know the drill. If it's the first client, they're obviously concerned that the processes I use will be defensible, they'll hold up in court, they're not going to subject them to claims of spoliation or alteration of the evidence. So for those people, I do want to help them understand the fact that write blocking will be used so that the data will be preserved, that hash authentication will be used, that it will be a full bitstream copy that will bring in not only the active data but the forensically significant areas unavailable to the user. I'll go chapter and verse as much as until their eyes glaze over completely if they want to know the answer.
Which in my experience is about 5 minutes into the
5 minutes is generous, but yes, indeed.
Now, when you're doing that, here's the other problem area I think of. What sort of reasonable expectations do you have to set with people if you're dealing with a phone, which may present its own set of unique problems? Has the client always been aware of what the hurdles to phone acquisition may be?
No, I think that increasingly I'm having to have conversations, not only for phones but for computers, about the presence of encryption, full disk encryption, the need for credentials, the need for access codes to be able to get the information. In the past in forensics, it was a simple matter to bypass all of that. Frankly, most of that was window dressing from a security standpoint. But going forward, we've started to see, particularly in the corporate setting, genuinely locked down data, so I have to make sure that in the acquisition the data I'm getting is going to be unencrypted or can be unencrypted, and the same for the phone. I'm going to need some assurances that I'll have the credentials required to be able to decrypt the data and open the phone for acquisition.
The idea being you don't want to waste time. When you go to start the acquisition, you want to be able to start the process.
Well, it's time, it's the ability to validate the data. You talked about on-site acquisition versus lab acquisition. I prefer to have devices shipped to me, overnighted to me, rather than me go to the devices, because in my lab, the meter doesn't run all the time. I don't have to charge every second.
Right.
I can start a process going, move on to something else, or take a break, and I'm not charging for my time. On premises, it's running all the time. So it can be prohibitively expensive to require an examiner to go to the media rather than provide the media to the examiner in the examiner's lab.
Gotcha. What about, last kind of preliminary question here, and I don't know if this has even come up yet, any requests for acquiring and or examining data that's been stored on the cloud, web-based services anywhere yet? Has that raised its ugly head yet?
Yeah, most commonly the data that I'm being asked to acquire and analyze is software as a service data,
right,
which the listeners would know as webmail, Gmail, things of that nature, Salesforce data. So and data in Dropbox and Google Drive and so forth. So yes, there will be efforts. Those are tend to be more towards eDiscovery style efforts than what you'd call true media forensics efforts. I can't do media forensics on cloud media. I don't have access to Google servers, and even if I did, the idea of acquiring Google is largely laughable. So once we move into the cloud, the nature of the forensics changes. It's not going to be that kind of I can bring it back from the dead forensics, but there may nevertheless be files and data and databases stored in the cloud that those applications and the data that makes up those applications is subject to further examination, possibly even bringing back data that's not available, not seen by the user. So more of the forensics magic can still be performed on the data, but not upon the physical media, the storage media, when we start talking about the cloud.
And when you speak about magic, when you put the forensics hat on, is it the Karnak type turbine, or?
Of course. Yes. Yeah, but of course it's made of copper so that they can't beam into my head. Because as I've moved up in the practice, I went from the original tinfoil helmets that I see you wear regularly, and I now have the beautiful gold lame copper line.
Very good.
Helmet, which you saw me wear at Mardi Gras lately. Those of you who were at least saw the pictures.
And also a little known side effect, it is a bead magnet.
It is indeed a bead magnet, not a babe magnet, but a bead magnet.
You got to go with what you got, right?
Yes, indeed.
So, are all of these considerations? Do you have a checklist that you use or give to the client ahead of time? Or is this just part of the discussion you have with them when you meet with them the first time?
When I started, I obviously had lots of checklists, and the process had to be well documented, and I still document acquisition closely,
of course,
but I do it differently now. Some of the necessary information I collect is collected in the process of imaging the data. I photograph extensively, and as a consequence of that, I don't find I have to use paper. I'm just not a paper guy. I'm a digital evidence guy.
Right.
So the data, the records that I make electronically. The records I make are made photographically or made by the software that I use that monitor what I do.
Right.
So I can recreate and I can demonstrate what I did and what I didn't do in the process.
Huh. And that leads then to one of your other points that you had sent me in this email that you when we first started talking about this, establishing the scope and the protocol for the examination. That's
so important and so critical. I cannot tell you how many times I've gotten either appointed by the court or brought in by the parties, and I'm told that they've already agreed to what I'm going to do, and it'll be things like undelete all files and place them in, calendar, temporal order, and so forth. What they don't understand is that when you're working with deleted forensically significant artifacts, you don't have the same complement of metadata. You don't have the ability to undelete everything. So it's great that they've seen something on, NCIS New Orleans,
yeah.
or CSI Cyber, or they've seen something in a movie where somebody, a hacker pushes a button, tips a couple of keys, and all the data, the collect evidence button is pushed and all the data comes back. That's not forensics. And so there are things I can do, and I want them to know what I can do. I can often carve the deleted data out, artifacts. I may not know what it was originally called, but I can often bring back the content. But I can't simply go back in time and tell them exactly what happened at a certain moment. I can't often tell them exactly what files were copied onto a thumb drive. There may be artifacts, but those kinds of activities are not routinely and granularly logged by Windows or by Mac. And so we have to look at a variety of artifacts and correlate those artifacts with what they tend to mean in terms of human behavior. So it's important to sit down with a forensic examiner and gain realistic expectations about what forensics can do and cannot do. And I think it's important with a trusted examiner to provide a level of discretion for the examiner to follow the evidence. You cannot anticipate all you may find, and so a good examiner will be able to bring other tools and techniques to bear as new things crop up, which leads me to the number one question I get, Tom, if you can imagine, is how long is this going to take and what's it going to cost? And I mean, understandably, that's a key question. And I wish I could answer it. People ask me, okay, we want you to do forensics on a machine, what's it going to cost? And I'll ask the question, well, what's the operating system? We don't know.
Yeah.
Where's the machine? Well, we're not sure. Is it encrypted? Is it not encrypted? We don't know. How large is the drive? How long has it been in use? Do you have evidence that the individuals tried to hide evidence or not? I don't know. And so I have to say to my clients, look, imagine a client comes into your office and says, I have a case, I have a claim. What are you going to charge me to try it to a verdict? How many witnesses? We don't know. What's the case about? I can't tell you. How much is at stake? I can't tell you that. And we go on and so forth. I mean, how can you price the cost to bring a case to fruition if you know nothing about the case, the parties, the venue, the issues? You can't. Yeah. And that's kind of what I feel when someone comes to me with a hypothetical computer. How many computers? Well, we don't know. There could be one. There could be several. Okay. Are there phones? Well, are there distal media, CDs, external hard drives, thumb drives? I mean, come on, folks. I can't give you a price if I don't know anything about the amount of work and data and the amount of processes that must be brought to bear. So if you come to an examiner, try to come with an idea of what is the computer in terms of its relative age and the operating system that it runs, whether it's been secured by encryption, a rough idea of the capacity of the hard drive or drives that will be under analysis. It's not a big deal to analyze, a 1 terabyte drive versus a 500 gigabyte drive, but it is twice as much stuff to go through sometimes. And that means twice as much time to acquire, twice as much time to process, to analyze. I mean, the amount of data, as with eDiscovery, bears a direct impact on certainly the cost of the mechanical processes, which in my work, machine time, I don't charge for machine time, so if something takes longer, my meter's not running in the lab, as I said. But an analysis time, my time going through artifacts, assessing whether they're relevant, not relevant, all of that takes billable time and adds to the ultimate bottom line of the analysis. So what I might suggest, may I suggest something? Yes. All right. What I might suggest is set some touchstone periods. Like, for example, I have an engagement fee that counts towards my time worked. And what I'll often say to my clients is, I won't go past this number. This is what you'll pay me up front. As we approach this number, we need to sit down, look at what I've seen and found so far, and make an assessment of whether or not you want me to go forward, if you want to change the scope, or at some sort of a milestone along the way to communicate with the client and say, here's where we are, here's what it's costing, here's what I project it may cost going forward, so that there are no surprises with regard to the cost of process. The problem is, if you need to know that up front and you can't give me a very specific detail about what it is I'm going to be doing, it becomes difficult for me to give you a very reliable and specific estimate of cost.
Right. Part of that discussion, it would also seem to me, one of the other notes on your list here was testimonial needs and expectations. Obviously, you've talked about doing an examination and reporting back to the client. The scope and the costs are going to change if you're required to testify once or perhaps even multiple times.
It's not only that, obviously, that costs money. You don't have to provide time for reporting. If you need well-researched, well-documented, supported reports, just as lawyers will charge for quality.
As opposed to sloppy slipshod.
Well, let me tell you, Tom, in this industry of computer forensics, there are many examiners who think reporting is done by the software. And that they push a button and a tool like NCASE or FTK or another one will spit out reports.
And that's the end of it, yes.
Incomprehensible for the most part as a deliverable to the attorney.
And I can tell you, in my work with the federal defenders, where we were often given those sorts of reports, yes, to the average client, they are going to be incomprehensible.
Right. So part of the art of this work being done well, in my opinion, is the ability to speak not just geek, but speak law, and be able to translate what those artifacts on a vast list of link files, prefetch files, etc., what they mean in terms of human behavior and how reliable they are, so that you can take forensic data and turn it into case-specific probative information that can be put before a trier of fact. So it's not only the ability to report and the time necessary to do that, which can be considerable if it's quality, just like good briefing takes time, good forensic analysis and reporting takes time. It is also a function of, is the person qualified to do the examination also a person who will perform well as a witness in a challenge situation. Not everyone is a natural witness. Not everyone can follow the rules of testimony, of listening to the question, answering that question.
And especially in our world of technical proficiency, you can have someone with great technical expertise who doesn't convey that well or easily. And so, yes, that could be an enormous problem.
And I don't want to say, obviously polish can blow up on you, I suppose. Yeah. Someone who's too glib, too sure of themselves can alienate a jury. And somebody who is young and altruistic and so forth, and comes across fresh-faced and honest, that can be a great witness. So it's not that you need the seasoned old hand with the gray hair.
Hey. Easy now.
Though that can be an advantage too.
Or beard, as the case may be.
It's that not everybody has testified. Not everybody is an effective communicator and can use the analogies and the demonstrative evidence that is necessary often to help a judge or a jury understand why the testimony being related is trustworthy or what happened. You don't want to confuse a jury. You want a jury and a judge to feel they understand what's happened well enough to have confidence in their ability to answer the special issues, to bring forward a verdict that favors your client. So I think that there's a great deal of this that goes to that issue too.
Point out the being able to withstand the rigors of an aggressive cross-examination. You have to have the temperament to understand that you're there to just testify about facts and not let opposing counsel get under be a burr under your saddle, so to speak.
And not everybody has the ability to maintain their composure and not rise from the bait. I'm not saying I do, but certainly it's challenging.
No,
and an effective
skill set.
cross-examination is, I've found that young examiners, and I've written about this, guiding younger examiners and inexperienced examiners as a witness,
really,
how to be a more effective witness.
Something on your website? I mean, I know you capture.
There is an article about how to be a better forensic witness.
That site is, for the 2 people in our audience who've never seen it,
craigball.com is one place to go for that, craigball.com. And so one of the things that I like to tell witnesses is that they I lost my train of thought, Tom. I started spelling my name and I lost my train of thought. But there is an article
Once I saw
there
my name in light,
that I talk about
how to be a good witness.
But also and anticipating the question, not getting yourself boxed in, being not speculating. There is an art and an arc to this. And it's very easy. One of the big mistakes people do is they get pulled outside of their area of expertise.
Right.
You're not an expert on everything, not even every aspect of forensics necessarily. And so it's very easy for someone's ego to take umbrage, and all of a sudden you're expressing opinions that you're neither trained, qualified, or have the necessary foundation to offer.
Yeah.
That's an easy mistake to make, answering improperly formed hypothetical questions. Here's the problem. Most witnesses can rely upon skilled counsel, their counsel, if you will, to bring forward the proper objections. But as we move into the highly technical information, it's much more challenging for counsel who is presenting the witness on direct to be prepared to make the proper objections on cross-examination. I find that if I have one criticism of counsel when it comes to forensic examination, they don't take the necessary time to work with the examiner and understand what the examiner is saying so that they can ask the proper questions on direct to elicit the information. They can understand where things are going on cross to provide appropriate protection, and then to ask the proper rehabilitation questions where necessary, or redirect questions where appropriate, to correct those things that may have gone off the rails on cross-examination. Of course it's technical and you hired an expert to do it, but the expert is not there to take the place of counsel's role. Hopefully a good expert is there to school counsel to better understand what the expert is saying and better integrate that into the case, into the direct examination, into the final argument, and into meeting the obligations to have all the necessary elements of proof.
Okay. One last question.
Okay.
An issue you said should be discussed, and that is the different roles and duties of a neutral examiner versus a partisan examiner.
Agreed.
Your thoughts? Well, you should agree. You wrote it.
I did. I agree. I think that's an excellent question, Tom. More power to you. But I think it's an important issue.
How so?
Many times, someone will come to me and say, "We want to engage you as a forensic examiner." I'll say to them, first of all, don't tell me anything more about the issue for a moment. Is this something where achieving what you want in terms of getting to the other side's media is more likely to be feasible using a neutral examiner whose primary duty is to the court, perhaps paid by one or both parties, but ultimately is standing in the shoes of the court, who is then able to see such things as privileged information without triggering a waiver of that privilege, who can balance the legitimate interests of both sides, one side to getting to the relevant non-privileged evidence and the other side in protecting non-relevant privileged evidence. A neutral can do that.
And if the answer to that question is yes, you'd recommend getting a court-appointed neutral?
Then think about working with the other side to use a neutral examiner.
Gotcha.
It's a tremendous advantage to both sides. The examiner, as I say, can see everything with less of a fight because the examiner is not turning it over to the other side, and the examiner can take the appropriate steps, use the examiner's own judgment working with the court to make sure that information of the type that people want to protect and have legitimate rights to protect will be properly protected. So a neutral is the way to go, I see, in many, many cases, simply because you're not going to get to the other side's media if you're not using a neutral. You're either going to have to get their examiner, they'll be forced to get an examiner, and force that examiner to use a protocol that is calculated to get what you're needing, get the questions answered, or you can work with a neutral, and then that neutral will work with both sides and the court if necessary to come up with a protocol that's calculated to be as narrow as it should be, as low cost as it should be, but at the same time be reasonably likely to get the questions that need to be answered.
Okay, good. Closing thoughts? Anything that...
Well, Tom, what have you been working on lately? They've heard me blather on. What have you been up to lately?
About 2:35. It's springtime, crawfish season.
It is. It's springtime in New Orleans. We've had some beautiful weather, just like today.
This is gorgeous.
And folks, if you're listening to this, we're heading into festival season.
It is big time.
We've got French Quarter Fest coming up. Any number of food-related fests coming up. You can't have a food where we don't have a fest for
it. The 300th anniversary celebrations will be in mid-April with the tall ships coming in.
Tons going on.
Large U.S. naval contingent coming in.
Perhaps any notable music festivals we would want to mention?
It seems to me there's one coming up at the end of April.
What's it called?
The Jazz Fest.
Jazz Fest, yes.
Which will be held really a hop, skip, and a jump from where we're sitting.
Across the street from your home.
I should point out that during Jazz Fest, which is on 2 successive weekends, the last weekend in April, the first weekend in May, there's a wonderful crawfish festival put on by a friend of mine who is best known as Shaggy, the Crawfish King. But he has now instituted, he started it last year, a large music festival at the Crawfish Festival, which will be on the Tuesday and Wednesday between the weekends over in Mid-City. He's got Tab Benoit, John Cleary, the Lost Bay City Ramblers, and a personal favorite of mine these days, Samantha Fish. Great guitarist, vocalist.
She will also be at Jazz Fest.
I think all of those people will be performing at Jazz Fest as well.
Wonderful.
If you get a chance to see Samantha Fish twice in a week, I would take it. I believe Tab and Samantha are also going to be playing one night at 3 a.m. at some club someplace, which also goes on during Jazz Fest. Those days are past in my experience. The 3 a.m.
they are dwindling away to a precious few as well.
Our dear friend Dave Glynn from the Chicago Law Bulletin, who's coming down the first weekend of Jazz Fest, we talked about Tab Benoit and Sonny Landreth are playing at the Rockin' Bowl that Sunday night, but the show doesn't start till 11. And Dave just shook his head and goes, "Yeah, that's just not
too
possible.
Late.
It's just not possible."
All right. So,
man.
But listeners, if you can't make it down for those, come down any week, any weekend, because throughout the spring and the early summer, there are going to be people. People are boiling crawfish on almost every corner. They're often free to say, "Come on in and grab a plate." And if you haven't experienced the unmitigated joy of sucking the heads off of mud bugs and eating the corn and red potatoes and all that stuff, and drinking the beer and the fellowship that goes on, and women's ship, what was the gal ship, whatever it is. People ship. Yes, thank you, sir. Yeah. That goes along with it, and the spontaneous musical performances and all the joy that is New Orleans. Come on down.
As you can see, Craig's getting in the mood for.
I don't even eat crawfish. I don't eat shellfish or fish, but
I
just love.
Beer,
I love going to the
it.
things.
Yeah,
it's the people are the greatest asset this area has, and you'll love them. Come on down. Have fun with us.
So if we don't see you at Jazz Fest or someplace around New Orleans before then, we will see you next time on the eDiscovery channel. Thanks for tuning in.
Thanks again. Thanks, Tom.
Thank you.
Let's see if we got that to work.
Yeah, I certainly hope so.